All right, it is Friday, September 19th at 7 p.m. Eastern. This is the Libertarian National Committee Executive Committee meeting, and I will be calling this meeting to order. Mr. Secretary, if you could proceed with roll.
Chair Nikela,
Present.
Vice Chair Dar,
Present.
Treasurer Redpath,
Yes.
Secretary is present. Mr. Ford.
Yep.
Mr. Watkins. Mr. Watkins does not appear to be here or in the waiting room. Mr. Chair, we have 5 present and 1 absent.
All right, we have quorum. So we'll move on to the first item on the agenda, which I believe is
Adoption of the agenda.
Oh, yes, of course. The adoption of the agenda. The chair will now entertain a motion to adopt the agenda.
I move to adopt the agenda as presented.
Is there a second?
Second.
Any discussion? All right, hearing none. Is there any objection to adopting the agenda? The agenda is adopted. All right, so new business with previous notice, motion to recommend the LNC ratify the motions to dismiss the LNC versus Best lawsuit. So what that means is this would be a recommendation to the LNC to adopt a ratification to dismiss. I'm not sure if Mr. Hall is going to be joining us. I did invite him, but he may have other obligations tonight, so he said he may or may not hop on. Essentially, back last year, we between Ackerman and Fox Rothschild, I think at the time it was just Fox Rothschild, decided to make a motion to dismiss the case for the judge to dismiss the case. And we had a new judge since then. Originally, the motion to dismiss was not well taken by the court. We have a new judge. We did decide to do another motion to dismiss, so it's already been done. It's already been submitted. Our policy manual requires the ExCom to make a recommendation to the LNC and for the LNC to adopt that recommendation. So we're trying to go back and essentially ratify the decisions that were made both by myself and my predecessor. I apologize to the board if this didn't come sooner. We'll be sure to try to, in the future, make sure we go through this path to get there. However, it has been brought up in multiple LNC meetings that this was a strategy, and nobody seemed to raise any objections to it. So we just want to make sure we're all still aligned on this. And if we're not, I guess this would be a time where the LNC could disagree with that decision. So this would just be a motion to recommend to the LNC, which would have to adopt this recommendation to ratify the decisions laid out in the policy manual to dismiss the LNC versus Best derivative suit, to ask the judge to dismiss the case. Is there any questions so far? Mr. McMahon.
Just to speak on it, if we're able to do that at this point.
Sure, I think so.
Yeah. So I have concerns that I want to express. I'll start by saying it really doesn't matter because it's already been filed and I think it's already past the deadline. So this is kind of a formality. But what I'd like to speak to is process. I had asked for us to consider what is the best option for the LNC. I'm not an attorney. I don't play one on TV. And so I'm not sure. And so I wanted us to get an outside counsel who's not vested in either way. Ackerman firm, while we're their clients, they actually work for the insurance company. Ms. Vest's lawyers obviously have a position, and our legal counsel has, the position of ending any litigation is good. Being in litigation is bad when you're the supposed, defendant. But there have been questions as to, is this the best way to get restorative action? Is this, not settling and joining this lawsuit, or seeking our own lawsuit, or doing nothing? So I would have liked to have seen this come about by a conversation with a dispassionate third-party neutral attorney to make a recommendation on what the best course of action would be for us. But at this point, it doesn't really matter, because it's already been filed. It's already done. And the deadline's already passed, and it's being considered by the judge now. So, and I don't think asking the court to throw out a motion to dismiss that we may have filed would make us look very good in that court's eyes. So, but it's just, this is a procedure thing that I think moving forward, hopefully we don't ever find ourselves in this position again, but in any other like-minded situation, I think that we should be more engaged in this process, and maybe not always relying on one answer, that we sometimes seek outside opinions and outside counsel as to what the best outcome is. Because, to be blunt, everyone involved has an agenda. Everybody has something. Vest's team obviously has a vested interest. That's a fun play on words there that I just noticed. You know, the attorneys representing us currently, they have a vested interest. So I would have liked to have seen somebody more independent outside that can give us all of the options, and for us to be able to choose from there. With that, I yield.
And I will say, if the ExCom decides at one point to recommend, or in a future similar situation, the ExCom decides to recommend the creation of a litigation committee, which would stay on top of this particular piece of litigation and try to help us navigate it. That is something that the policy manual empowers us to do that we did not do. So that may be an option moving forward that might help assuage some concerns and make some recommendations, instead of just handing it off to the attorneys and letting them just do whatever they think is best. Mr. Ford.
Just if we could stipulate a couple of facts or near facts, what did this end up costing us? We reserve money for litigation. Is there any chance any of that it still is out there? And is there an avenue to collect legal fees from the failed plaintiff from this suit?
It's a very good question. I believe we've spent thus far about $25,000, which is our D&O deductible. Everything else has been paid for by the insurance carrier. I'm not sure at this point if there is any ability to recover funds in regards to what's been spent due to the nature of the suit. That is the topic we could explore, though. I could ask Oliver and Ackerman what their thoughts were on that and see if that's something that we could explore. But I don't have an answer for you right now. If Oliver hops on, I'll let you re-ask that question.
Thank you, Mr. Chair.
Mr. Chair, I would
All right,
point out
Mr.
that
McQuinn.
I muted Mr. Redpath, and I don't know if he knows how to raise his hand on his phone. So you may want to ask him if he'd like to speak, because I don't know if he does.
Mr. Redpath, did you wish to comment? You're muted if you do wish to comment. You're still muted. I don't know if you can hear us or if you wish to talk, but you're muted. And we're going to need unmute to vote in about a minute here, if not. Bill, if you can hear me, and you can't, unmute yourself, call me, or call Evan. All right,
I'm watching my phone in case he does call me.
gotcha. All right, is there no further discussion from the ExCom at this time? Hearing none, we'll go ahead and move to a vote. Mr. Secretary, whenever you're ready for roll call.
Chair Michaela,
I vote aye.
Vice Chair Dar,
I vote yes.
Treasurer Redpath, he's still muted. I'll vote yes. Mr. Ford,
Yes,
Mr. Chair, will you give me a couple of seconds to mute
Sure.
myself and call Mr. Redpath, see if we can get him squared away here?
Not a problem.
Okay. Okay, I've got Mr. Redpath on speakerphone. Go ahead. Go ahead and say that again, Bill.
Yes. I will vote yes.
I hear yes.
Okay, I'm going to keep him on speakerphone.
Fantastic.
Mr. Watkins is not present. The vote, Mr. Chair, is 5 yes, 0 no's.
Motion passes.
Okay.
All right, next on the docket, I believe, is a motion to recommend to the LNC that the LNC becomes a co-plaintiff in the New Mexico ballot access case. We had discussed with New Mexico State Chair Derek Scott, as well as their legal counsel, in regards to what they need from us in terms of support. Oliver Hull will be doing some pro bono work for the organization in New Mexico to get them to essentially sue the Secretary of State. The LNC, he believes, did receive material harm due to what happened in New Mexico in regards to ballot access. And he does recommend that the LNC becomes a co-plaintiff in this case. He thinks it would strengthen the New Mexico argument, and it would put the LNC behind it, which would give us something to bite at the apple with. So that's what he's recommending. I was hoping he could be here tonight to explain a little bit more, but that's what I got so far. Mr. Dar.
Yes, so we've already allocated, $5,000 towards any fees that need to be paid apart about this. Mr. Hall is going to be representing pro bono there, just covering some of the information that's normally covered when I was just looking at the policy manual of what should be discussed as part of joining a lawsuit there. So we talked about its purpose, its estimated cost, and that this gives us the continuing on the budgetary authority has already been advanced in a previous motion. So in this case, we're just joining something that has already been budgeted and allocated for. I believe we should show support to the New Mexico affiliate there. This is against the Secretary of State or the state itself. It could be in federal or state court, depending on the courses that need to be taken there. And I feel this is best for ballot access within the state that we are being disenfranchised by the state for ballot access purposes in New Mexico there. And we should fight for the affiliate party there alongside them. That's all I have to say. Thank you.
Thank you, Mr. Dar. All right, is there any further questions from the ExCom? Mr. McMahon.
More of a statement that, the Secretary of State did our affiliate dirty by mislabeling our candidate on the ballot, and then used that mislabeling to claim that our affiliate doesn't have ballot access. I think that it is highly appropriate for us to, not only help fund it, but to join as a co-plaintiff in it. So I'm very supportive of us doing whatever we can in this case to smack down the Secretary of State's abusive actions against our affiliate. And I'm ready to call the roll whenever you want, Mr. Chair.
All right, I think we're ready.
Chair Nikayla,
I vote aye.
Vice Chair Dar,
I vote yes.
Treasurer Redpath.
Yeah.
Do you guys hear as yes?
Yep, take that as a yes.
I vote yes. Mr. Ford,
Yes,
Mr. Watkins is not present. The votes, Mr. Chair, are 7 yes, or well, 5 yes, 0 no's.
Motion passes. All right, I think that's it. The chair will now entertain a motion to adjourn. Is
Hold
that
on,
it?
Mr. Chair. Before we move to adjourn, did we have anything that we needed to discuss with Mr. Hall?
He told me he was watching his kids and he wasn't sure if he was going to make it, but he was going to try to budget 15 minutes. So I suppose he can't make it. So if there is something that comes up, I'll have him address the LNC. I just asked him to come on to explain a little bit more about the New Mexico issues, but if the LNC wants, we could spend another time having him talk
I
to us
think
about
I
it.
think we're pretty versed on what's going on in New
Yeah,
Mexico. So I think that the bigger question that I have is just the getting a statement of process from him, like what are the next steps, what's going to happen now, type of thing.
I do see two hands raised, Mr. Ford and Mr. Dar. Mr. Ford.
yeah, just to follow up on my line of questioning earlier, I do feel it's important for us, if possible, if it's deemed sound by our attorneys, to pursue legal fees. This lawsuit from the get-go has cost us time and money and resources. And I in the legal world, they sometimes call it slap lawsuits, where you just throw a lawsuit out there in an attempt to suppress people. Yeah, I just thought this entire process was unseemly and unnecessary. And at this point, the fact that it's still continuing at some level, when they've, in a sense, received the relief that they were looking for, just points out just how unfortunate this whole thing is. And quite frankly, we spent a lot of money. That's money that can be spent on ballot access. So thank you, sir.
20,
Oh,
25 grand.
can I give one piece of good news, or is that out of?
I like good news.
Well, I expressed this to you the other night. I just want to congratulate the Libertarian Party of Massachusetts. They appeared, I was fortunate enough to be there as well, but they appeared before a joint commission on veterans and military affairs before the Massachusetts General Assembly. Joint, that it was the Senate and the House. They were professional, they were on point, they were poignant, but at the same time, highly focused. It was the video, we just got the video, and I hope to share it with folks as an inspiration. There's a lot of great testimony that's gone out there for Defend the Guard, and this is in addition to that, and it just shows what we're capable of when we can focus on what's important.
And I will say, Pat, at our last Libertarian Party Florida Keys meeting, we sent out mailers to everybody in the county. We had a gentleman show up. He moved to the Keys 30 years ago. He was the prior chair of Rhode Island. So I want to get you connected with him. I'm sure he's got a wealth of knowledge, but yeah, super interesting.
Absolutely. Well, congratulations to Massachusetts and everyone who's fighting the good fight for Defend the Guard. And get your hotel room, darn it. Get your hotel room to the convention.
Mr. Dar.
I was going to make the motion to adjourn.
Oh, Oliver Hall just texted me literally
Oh.
as you were about to speak, so he's calling in. So I guess
I was misspeaking. Sorry.
I would just,
you come a little fuzzy there.
Mr. Chair, I would just ask Mr. Hall to send us
Sure.
an email that spells out what the process will be for New Mexico. That's the only question I had.
Understood. Does the body still want to hear from Mr. Hall, or should I just let him know? Just email us.
I would like to hear from him. I would just, that
Okay.
one.
Oh, that's right. I forgot Mr. Ford had that question.
Okay. He says he's calling in.
I don't see him.
Let's see, Zoom link. Select format.
I still don't see Mr. Hall calling in.
See you.
While waiting for him, we on Project Archimedes 2, or as it is known, we've gotten what, $30,000 in checks was the number, Mr. Chair?
So we received, I think it was $39,000.
39 now. Okay.
Something like that. Something like that.
There's still checks to be entered, but that's from the first mailing based on it. So in the realm of good news,
I was on the call with the gentleman today. He donated $10,000 and he's pledged $5,000 a year. He really liked that newsletter. And we got more to come. We're working on with our friends in the data side to get some data to reach out to more people, registered libertarians. So I'm very excited. Yeah, we had I think so far 800% return, something like that. Maybe 1,000% return. So that's pretty darn cool. So a little bit of good news for those at home. Okay, Oliver says just a minute. So for those who haven't seen, we had a really cool X Space week
There's Mr.
or so
Hall.
ago. Oh, never mind. I was going to go on a
He's
tangent.
joining now.
Perfect.
Okay, Mr. Hall is here.
Good evening, Mr. Hall. Can you hear us?
You're muted, Mr. Hall.
Hi, I can hear you.
All right, excellent. We did just go through, we made a motion to ratify the dismissals according to the policy manual recommendation to the LNC. We also passed a recommendation to the LNC, which will have to be voted on later as well, to join in with the New Mexico suit against the Secretary of State. Do you want to give us a little bit of background on that? I gave a brief elevator pitch on what's going on there. And I know Mr. Ford had some questions as well regarding the Beth Vest suit.
Sure. My apologies for calling in a little bit late. On New Mexico, as I think probably everybody knows, the state affiliate recognized by the LNC is named the Free New Mexico Party. There's another party operating in New Mexico, or another entity, I guess I should say, called the Libertarian Party of New Mexico, which the LNC doesn't recognize. So there's a separate issue there. But essentially, the Free New Mexico Party successfully petitioned to qualify for the 2024 ballot. They nominated Chase Oliver and Mike Termott. They were entitled to place their candidates on the ballot. Under state law, they, of course, have the right to place their candidate on the state ballot under their correct name and party emblem. The Secretary of State made a mistake and placed Chase Oliver and Mike Termott on the New Mexico ballot under the name Libertarian, which would obviously confuse the representatives, the supporters of the Free New Mexico Party, voters when they go to the poll wanting to support the Free New Mexico Party see Chase Oliver and Mike Tremont on the ballot, but listed as Libertarian, knowing that there's another entity out there called the Libertarian Party of New Mexico that is not affiliated with the Libertarian Party, obviously is going to create voter confusion and, in my view, harms the First Amendment rights of the Free New Mexico Party, the candidates it nominated, and its voters, all of whom have an associational right to be on the New Mexico ballot under the proper party name. And they were not. And, you know, it's hard to say how many votes may have been lost as a result of the Secretary of State's error. We have some thoughts about ways to quantify that for purposes of a lawsuit, but it's essentially unknowable. But what is known is that their First Amendment rights were harmed as a result of the Secretary of State error. Following the election, the Secretary of State sent the Free New Mexico Party a letter notifying them that they were being disqualified from the ballot because they didn't receive the requisite number of votes in the presidential election to retain ballot access. And so they have been disqualified. The problem with this, of course, is that they were never on the ballot. And so under New Mexico law, the statute that the Secretary of State is citing, it says that a party who runs a candidate for governor or president and fails to get, I believe it's 2% of the vote in the election, it must be disqualified. Well, that doesn't even apply to the Free New Mexico Party. So what the Secretary of State's done here, though initially in error, is not even authorized by state law. And so we sent a demand letter and kind of laid this all out for the Secretary of State and explained that, look, you guys clearly made an error here. It's not the Free New Mexico Party's fault. And really the only remedy is to allow them to be on the ballot in 2026. They did everything they were required to do under state law to qualify for the ballot. You never actually placed them on the ballot. Now you're disqualifying them and saying they didn't get enough votes when they never were on the ballot in the first place. So it's, you know, it's kind of a funny case in that, of course, the Free New Mexico Party wants to be known as the Libertarian Party of New Mexico, and we're going to be taking action against that other entity to try to stop them from using the name Libertarian. But it's just a factually kind of quirky scenario. I don't view it as a slam dunk case for the reason that the candidates that the Free New Mexico Party wanted to put on the ballot were on the ballot, and they were on the ballot under the wrong name, but the wrong name happened to be Libertarian, which is the name the Free New Mexico Party wanted to use, but they were prohibited from using because the other entity was already using it. So all of these facts make it kind of quirky and a little awkward. So I don't think it's like a slam dunk case that will definitely win. On the other hand, it's clear that the Secretary of State made a significant mistake, which infringed on the Free New Mexico Party's rights, the Chase Oliver and Mike Tremont campaign's rights, and voters' rights. And when we sent a demand letter, the Secretary of State's office responded that they were going to, you know, the demand letter was basically recognize these guys for 2026, don't make them petition again. And they said they were going to respond, and they told us 4 or 5 times over the course of a few months they were going to respond, and then they just stopped answering my emails. So I think they are clearly in the wrong. I'm not sure if a court will agree that the party deserves to be on the ballot for 2026 without petitioning, but that's the relief that we're going to request based on the violation of their First Amendment rights in 2024. And I think it's a reasonable demand for relief. They didn't get what they were entitled to under state law, and they ought to be given that right. Alternatively, we will request damages. they and the Libertarian National Committee spent significant funds on their petition drive, and they were denied access to the ballot, even though they completed a successful petition drive. So we'll also ask for money damages, the actual cost of the petition drive. And for that reason, I have recommended that the Libertarian National Committee join the case as a plaintiff. I think that's everything I need to say in summary of the case. Happy to take any questions.
Any questions? All right, I don't hear any. I know, Pat, do you have you want to re-ask your question? And Mr. Otis here, where we are still in open session. So I know Mr. Ford, he had a question about the Beth Vest case.
With regard to the Vest case, I was under the impression during the initial attempt to have the case thrown out, there would be an opportunity to get back some of our legal fees. Does that opportunity exist now? Have we exhausted the $25,000 that we reserved in terms of our quote unquote deductible, for lack of a better term? And where do our fees stand with that case? Any idea what totally we were out of pocket?
I don't think there was ever an opportunity to win attorney's fees in this case. The only time a defendant, in general, the only time a defendant can win attorney's fees against a plaintiff is when the plaintiff just files a clearly frivolous lawsuit. The standard is something like frivolous, vexatious, or I can't remember the other term, but basically it means there's just no basis for the lawsuit. It clearly never should have been filed. And I don't think, we're anywhere close to that territory. So there was never, I think, any realistic expectation of getting attorney's fees back. I don't know how much of the $25,000 deductible has been paid already, although I imagine it has probably been exhausted between paying two law firms now, Fox Rothschild, which is Ms. McCardle's counsel, and then Ackerman LLP, which is the LNC's counsel. Both of those are being covered by the insurance company, and the insurance company has only requested that the LNC pay the one deductible. I assume it has been exhausted. And again, I don't think there was ever any reasonable expectation of getting attorney's fees back from the plaintiffs.
Thank you very much.
All right, any other questions from the ExCom? Hearing none, Oliver, thank you so much for your time tonight. At this point, if there's no further questions, the chair will entertain a motion to adjourn.
Mr.
Motion
Chair,
to
I
adjourn.
move to adjourn.
Motion, is there a second?
Second.
Any objection? Hearing none, we are adjourned. Thank you very much, everybody. Have a great weekend.
Thank you.